Singer from National Council. That was our wonderful webmaster, Alicia, who's been running in and out of the room to solve our audio issues. Typically, I do a very brief introduction, but this is Judge Gonzalez and Professor Harp, who are both on our steering committee, and I'm going to turn it over to them in the interest of time. So take it away.
And this is Judge Gonzalez, so you understand my voice, but I'm going to let Karen get started. Go ahead, Karen.
All right, I trust you all can hear me. Let's move on with the first slide here. We're going to talk about discovery during the course of this webinar. There's nothing particularly complicated or scary about discovery. It's just the process that lawyers and courts use to discover what the case is about, to discover what evidence exists out there. And it's the way we go about sharing evidence. That's all it refers to. Evidence means virtually everything: records, documents, photos, testimony, statements, anything like that can be evidence in a case. Physical evidence, actual items can be evidence. And often it's in the possession of the opposing party or sometimes a third party, which might be where the players or the stakeholders in this pilot project, where they come in. All it does, it's the process that allows both parties, plaintiff and defendant, or the government and the defendant, to figure out what the information is, what the evidence is, analyze it, and figure out how they're going to use it in court. That's really pretty much all there is to it. The thing that you have to remember, though, is that defendants really have to share all the information that they want to use in court. During the process, the law is going to require parties to do that. That's why what we're generating, or what this project is generating, this screener, why it becomes so important, because the law requires information to be shared. And this screener is going to potentially unearth a lot of information, both that might tend to make a defendant look guilty, or that might tend to make a defendant look not guilty, or might mitigate the crime that's charged, make it look less violent or less serious or whatever than it might have been. So all of that information has to be provided and exchanged. Each state has different laws about how detailed the information has to be, but when the parties in a lawsuit are the government and a citizen, right, the state versus the defendant has a constitutionally protected right to know what evidence the state intends to present at trial, and has a right to know if the state has any information in its possession that tends to make the defendant look not guilty or less guilty. Either way, that's exculpatory information. The defendant, we'll talk later, the defendant has actually a lot fewer obligations to provide discovery than does the state, but they still have it. So that's kind of where what we're talking about right now.
So when we're talking specifically about criminal cases, you need to understand that the government is under a requirement, a constitutional requirement, to disclose that information. It all comes from a case that's called Brady versus Maryland, which is a Supreme Court case. And in that case, just to give you a little background before we get started, you had Brady and his buddy, Mr. Bobbitt, and they were accused of committing a crime. Mr. Brady was denied access and not given information that the prosecution had, where Mr. Bobbitt had admitted to doing the killing all by himself. And so despite the fact that Mr. Brady had said, well, I'm sort of involved, but Mr. Bobbitt did the crime, they did not turn over that piece of information. And ultimately, the Supreme Court said, no, that violated the due process clause of the 14th Amendment, and therefore the government can't do that. So let's talk about, what do you think this really means? Why is this? Can we have the next slide, Kelly? Kelly, there we go. So why do you think discovery is important for implementing what you are all trying to do in your respective areas? Let's unmute everybody and see if we can get some answers. Anybody?
This is Jenna from Virginia. I guess the one big component that I think of with discovery, and I know that I've had this conversation with Carlene and Kelly, is, obviously the screening tool is going to be getting some very intimate details, and those details, like Karen had mentioned, could either prove to be helpful or hurtful to a victim of crime. And thinking of working with folks in DJJ, obviously they're in that system based on a crime, but we're helping them basically, working through some of the traumatic issues while they're in probation or things like that. And so discovery becomes an important part of that process, because anything that arises can ultimately be used for or against them.
Okay. So you do have that potential. Anyone else?
This is Monique from Virginia as well. I think it also goes back to what was said earlier, in that there's a possibility that hearing some things may mitigate some potential sentencing options, or even within the risk assessment that may be done from the DJJ side. So I think gathering that information and knowing what the background is that a child may have could possibly be mitigating, and that could also create some challenges within the DJJ system with doing this screening tool, I guess.
That's absolutely correct. You do have to look not just at does it exonerate somebody, but also may mitigate sentencing or punishment later. But what about, what makes it important for implementing your system? Other than the fact that there is this evidence that could come to light?
I think it's protection. It's being upfront and making sure that they understand their rights, I would think.
I agree. When you're setting up your system, you want people to understand the limitations to the confidentiality that they may assume they have because of your relationship. What about for your staff? Why is this important?
Yes, being able to try to recognize what settings you're in and how you're conducting an interview.
Well, exactly, and you're also going to be part of a team, right? So you are going to be part of this, the government team that may be putting together their case. So you have to understand where you fit into that process as well, because it's not just the prosecutor that has this obligation, but others under the control of the prosecutor or the government's attorneys. Kelly, in the interest of time, let's move on. I think they have basically hit the two really important parts, which is you really have to think about the integrity of the process, and you are now, as part of your linking systems of care, you are part of the process, and there are certain ethical duties that you will have within your own disciplines, but there's also the understanding that when you are part of the process of government, that in a case where discovery is required of you, that it is the law. It helps to understand what that discovery recommendation or what that discovery obligation is, so that as you put your implementation together, you can strengthen your communications between yourselves and the courts and your other stakeholders, so that in the end, we don't wind up putting yourself in a situation where you may lose credibility with the stakeholders that you have, as well as lose your credibility with the defense bar. You don't want to seem like you don't know what the rules are that the game is played by, because that would also could result in liability to you. And in the end, just keep in mind that this is not an option. It's not something you can or cannot do. It's the law. So therefore, that's what has to happen. So we thought we would try and put some meat on the bones here by giving you some examples, and I hope everyone is familiar with those. And Karen's going to take you through the first problem.
All right, let's look at the first hypothetical. I'm trusting y'all have that. Here's the background. Heather's removed from her home after her parents are caught with drugs, fairly typical. Parents are arrested. Sarah screens Heather, and Heather says some of the drugs in the home were hers. Now, you can imagine that that is favorable to the defendant, right? Because it tends to show his innocence, or that perhaps not all of the drugs were his, or that they were all hers. Either way, it's information the defense needs. Sarah recorded the information in her case notes, and she has knowledge of the statement from her personal observation, all right? Now, what is likely to happen? What's the next thing? Should Sarah say anything to the Commonwealth's Attorney's Office? What do you all think? Do they have an obligation to say anything to the Commonwealth's Attorney?
This is Nancy. Doesn't that obligation have conditions based on the relationship between Sarah and Heather?
No.
The client confidentiality, how does that mesh with the other obligations of discovery?
No, I think we're going to find, we're going to continue talking about this, but Brady, holding on to exculpatory information, that Brady case is going to cut through confidentiality. That's part of the problem here. There is information that you're going to obtain through these interviews that you're doing, or these working through this screening tool, that confidentiality is going to be pierced. You're going to get right through that because it's exculpatory information that has to be turned over to defense. Now, it will depend to some extent on Sarah's actual relationship with Heather in this case. I mean, is it one of the protected privileges? Is it something that the law somehow protects? But if it's just a screener, somebody in probation, or somebody in one of the nonprofits supporting the system or something like that, there isn't going to be a confidentiality like that. And regardless, I think you're going to have to provide the information to the government's attorney, and they can go through the process of arguing about whether it needs to be disclosed or not disclosed. But the law in so many states imputes knowledge of that exculpatory information to the prosecutor, which means regardless of whether they actually know it exists, they are responsible as though they knew it existed. And that's why prosecutors get so anxious, nervous, upset about discovery and any exculpatory information that might be out there. So it may be privileged, but that is not likely those would be the rare instances, I think, when it would be privileged. So do you think Sarah has to tell them?
This is Laurie from Virginia, and so I worked in the prosecutor's office for about 4 years, and as victim witness, we were required to turn over anything that was exculpatory because we worked out of the prosecutor's office. However, it was kind of the general understanding that, for example, like in a domestic violence case, that, you know, if they shared information with the person who worked at the domestic violence program, they were not required to turn that over, and that was kind of general practice.
This is why each of your teams, or each state is going to have to get, each jurisdiction, each demonstration site is going to have to get with the Commonwealth's attorney where they are practicing to figure out what is practice in that jurisdiction or what is appropriate in that state. It's different for each state. And there may be kind of a common practice, as Lori was alluding to, but bottom line, if there's exculpatory information, it has to be provided. Now, it can show up redacted, or it can be reviewed in camera, and the judge can make some determinations about it, but the bottom line is exculpatory information needs to come forward. or at least be given to the prosecutor's office so they can make informed decisions about it, because they have ethical obligations that they have to meet. What do you think? Should Sarah say anything?
And I still have a conditional response for you that it depends on her scenario. If she is a counselor for Heather, then I think the confidentiality would still trump. If she was a probation officer screening, then absolutely.
All right. Again, it's Brady, and if this says if the prosecutor knows of it, he must turn it over to the defense, and that's true. But like I said, in so many jurisdictions, it is imputed to them. That the existence of it is imputed to them. And again, I think that you can alert a prosecutor that information exists without revealing what that information is, and work through that process of confidentiality versus discovery. But if we're going to go down this path of doing this, of eliciting this information for some reason other than, for example, if it was information elicited just to fill out this form and not to further therapy or diagnosis or something like that, then perhaps it's not going to be protected by confidentiality. There's just a lot of issues that are going to have to be sorted through. Let's see. Now, Sarah, let's assume, didn't store her information in a separate location. She just she wrote notes on his phone, or say Tom writes notes on his phone, then he saves them to the cloud and Google Docs. His case notes are subpoenaed. Does he have to print out and turn over his notes? Does it matter where you store the information? Do you think it matters at all?
No.
The answer is no, it doesn't. If it exists out there, it exists. And whether you put it on your phone, put it in the cloud, keep it in your head, it doesn't matter. If you know the information and you're part of a government operation, then that's it. It's exculpatory evidence in the control of the state, and it's going to have to be at least provided to the state so the state can determine what to do with it, argue about it, or what have you, but it's got to be revealed. There was one other thing.
Before we leave that slide, can we just go back? Because one of the other things that's really important and I don't want to lose it, is it's not just an obligation to provide this information to the prosecutor so the prosecutor is aware of what might happen, but you also have to consider that it is part of keeping the integrity of the court system. It's really about what we talked about earlier, about there being the integrity of the justice system as a whole. And you will lose credibility with the courts that you work with if you start being difficult where it comes to discovery. If you are not upfront and understanding that you can't play games here. Oh, I didn't keep it in my court file. I had it on a separate document, or I did an audio message into my phone, something that is my own private thing that doesn't belong to the court or doesn't belong to the agency that I work for. When you start doing that kind of thing, the court starts looking at you in a different light. And once you start losing the credibility of your program with the court, I think that's a really long-term problem, and it goes to undermine your viability to maintain a positive perspective with regard to your stakeholders. I didn't want to lose that. Sorry, Karen, for the interruption.
No, that's exactly right. That's just exactly right. And playing games with this and saying, well, I'm not going to write it down, therefore it's not discoverable, is just an error in thinking. That's not accurate. If you know about the information, you observed it, you heard the statement or what have you, regardless of whether you write it down, it's still within the possession of the state and has to be produced. And if you start playing games, then that's it. The credibility of this is lost. The utility of the whole project ends up being called into question. And when you get these, a subpoena ducis tecum or whatever it is that comes to you, which means to produce documents to the court, come to court with documents, if you look at it and say, well, you know, that's privileged information, they can't have it. You can't just take that subpoena and throw it on the floor in the trash and say, I'm not responding to it because it's privileged, and they don't get it. You have to engage in the process. You have to notify the state or whoever the attorney is for your agency. You have to respond or file a motion to quash or do various things. You can't just make a decision that it's not discoverable or it's protected by privilege and then not respond. You can't do that. You have to engage. And this is exactly about maintaining the integrity of the system. Okay. Judge, I think.
Yeah, I think let's talk a little bit more in depth, because I don't think we have any lawyers in the audience, that what it means to have a duty. And each of these prospective actors in this drama have a duty. And we'll start with the duty of the prosecutor. Okay, so the prosecutor, their primary duty is going to be seeking justice in the end, right? Seeking justice for the people, seeking justice for the victim. And to do that, they have to have information, and information is power, right? So they have to look and identify and see where that evidence is. But if they have it, they have to make sure that they're prepared to present it in a way that will lead to justice, right? And if they identify information that is not known to the defense, that falls under the Brady law, that means that it is a material information for purposes of exoneration or mitigation of punishment, they have to turn that over. And keep in mind that eventually we're going to talk a little bit about how to quash some of these subpoenas, but you're looking at, is it known to the defense? If not, is it exculpatory? And if it is, is it material? It can't just be every piece of information you have in your file. And when you talk about a prosecutor's team, you're talking about a much more expansive definition than just the people who are in the office, right? Not just the people who are sitting in the prosecutor's office. We're talking about law enforcement, probation officers. I prefer to think of it as the government, right? So we have the government, and everyone who's assisting the government in prosecuting their case are part of the prosecution team. And if information comes to them, it can be subject to discovery and disclosure. But the defense also has some duties, and they do, as the state has a duty to seek justice for the government, for the state, and for the individual. The ethical obligation of the defense attorney is to zealously represent their client, and so they have to look and see what they can do about finding the exculpatory evidence that they can find. It's their job to look under every nook and cranny that they can, whether they're investigating past acquaintances or past behaviors or bad acts. And they do have that obligation to secure and identify. They don't have that same obligation to disclose. They have the right of privilege, which means the communications between themselves and their clients are privileged. But there is one thing they cannot do, and that is that they can't conceal, destroy, or obscure that evidence. So although they don't have an affirmative obligation to turn things over, they cannot destroy things. And so that is what sort of makes them different from the prosecution. The prosecution must turn over, and the defense does not have to turn over, but they cannot conceal or destroy. So that takes us to problem number 2. And I think everyone has hopefully had a chance to get acquainted with problem number 2, which finally comes to probably the meat of what we do, which is getting a request for information. So you have a minor who discloses sexual abuse and perpetration during a screening. You have the person screening the minor does a mandated report as required by law, and the person screening the minor then scores the tool and takes the case notes about the statements. And lo and behold, the public defender does a discovery request, including Brady information. So the first thing that you have to decide is what in the name of heaven is Brady information, which was what we've been talking for the last 20 minutes or so. So you've read the fact scenario. So what information do you think at this point needs to be provided to that defense counsel? Anyone going to venture a guess?
This is Monique. I would think that they would want to know who, like who the victims were, what involvement that child had that's reported, where it took place maybe.
Exactly. And so you want to know who, what, when, and where, right? So they can figure it out. So they're looking for information that helps their case, right?
Absolutely.
All right. So if they're looking for things that help their case, this is where you wind up with your issues against confidentiality, correct?
Right.
Okay. And so Karen,
Yeah.
you want to take it over?
Sure. We talked a little bit already about that there are just limits on confidentiality. The way this whole process will get started is that you're going to get subpoenaed. And I know that people are nervous about that, but I think we're part of the court system, right? We're operating in the court system, and so we have to expect that at some point we're going to get served with subpoenas, no matter who we are, and especially y'all who are in there engaging with victims, witnesses, defendants, everyone. You're likely to get a subpoena, and it's just a way of getting you to the courtroom with whatever information you have. That's it. Lawyers have to have the ability to subpoena people to court. That's how we get folks to show up and testify. That's all. They are issued by the hundreds, as it says here. There are certain ways that it has to be served on you in order for them to have valid service, but you have to understand a defense attorney can sign and issue a subpoena as an officer of the court. They have an obligation to act in the best interest of their client and to put the best case on that they can possibly do. And of course, because he's a criminal defendant, so often nobody wants to testify on behalf or be seen as testifying on behalf of a criminal, so they won't show up. But now the defense attorneys have the ability to make that happen, and that's fair. They should. And then it has to be served on you. It must be physically handed to the person responsible for the information or evidence, and a proof of service must be filled out by the server. Okay, that's just the basics of a subpoena. Brady information, here we go. If a member of the prosecutor's team receives Brady information during a screening, that's not going to be confidential. That confidentiality is not going to protect that. The minor makes Brady statements or provides Brady during screening. That information becomes known to a member of the prosecutor's team. That's going to be discoverable. These kinds of questions, the drugs aren't mine, I was molested by somebody else, this other person made me shoot this person, all of this is stuff that has to be disclosed. Again, I can't stress establishing a really good working relationship with your prosecutor to make sure that they know about all of this information, because they have a tremendous ethical obligation to present it, and it's going to be imputed to them whether it's given to them or not often, and that is a huge source of difficulty for them. Defendants have a constitutional right to it, and it has to be provided. Here, though, it isn't completely invincible, and there are some things that are protected, and there's a process to do that. Psychiatric and mental health records. Sometimes some jurisdictions, New York was particularly kind of aggressive with this. Whenever there was a child who was a victim of sexual abuse or what have you in the juvenile system, they would routinely ask for all psychiatric mental health records, school records, child welfare records, all of this in an effort to get information about the child that they might be able to use for cross-examination, and we had to object to that all the time, and it was reviewed in camera by the court, and the court would determine if there was anything in those records that might possibly be exculpatory to the defendant. Often there wasn't, sometimes there was. Either way, that's for the court to determine, and that can be argued about, but some confidentiality will remain intact, but often that's going to end up being a decision for the court. Let's see if there's something else. Let's see. Judge, I think you were going to talk about this. Hello?
Judge Gonzalez, are you there? Okay, we may have lost her. Karen, why don't you jump in on slide 22?
Okay, I'm sorry. This is another thing that's kind of important for folks. Confidentiality doesn't mean you deny the existence of anything. If the document is or the information is subpoenaed, you have to.
Did you lose my audio?
Yes.
Okay.
Are you back?
I'm back.
Okay, go ahead.
Oh goodness, that was it. This is so much fun. Okay, so basically, don't make yourselves be questioned as to your credibility. Just if you have it, you don't say you don't have it, but you protect your sources by, if it's something you really think is confidential, then you need there's a mechanism for that. There's a request that the subpoena be quashed. That we're going to talk a little bit about how you can do that. But just try not to play any games. Let's try and get to some of that. So when somebody gives you a subpoena and it says a subpoena duces tecum, it says bring me the document. That's what it means. Bring me the document, and it's either a subpoena for the screening information itself, or just the screening in general. So it can either be specific or non. But if they're going to get specific, we're going to talk about motions to quash. And should we get to that, Karen? Because I think that's really important to talk about. You really don't have to put up with people laying a huge net out just trying to get information. The defense attorney has an obligation to do what they can to identify as specifically as they can the information that they're looking for. So they just can't go to the judge and say, okay, judge, I want a subpoena for everything, without giving any material reason or some connection between what they're asking for, the material they're asking for, and does it lead to information that's actually discoverable? Is it something that really needs to be turned over? So, and sometimes they don't, right? And sometimes they do. But you, the receiver of the subpoena, have the power to say, wait a minute, we aren't just going to turn this over. We need to ask the judge to take a look at this. So you can, a motion to quash is a request to a court, and you're asking the judge to either enforce all or part of the subpoena, or asking the judge to say, no, this is not going to happen, you can't have this, and I need the subpoena quashed. And there are certain guidelines that need to happen for that, and you want to take them through the deadlines or the timeline, Karen?
Yes, sure. This is just an example, so you'll have some idea of how these things, how quickly these things move through, and how essential it is that you don't sit on one of these when it gets served. If you're served on the 4th, for example,
which is today.
Yeah, that's true. But then you sit on it for a week and you don't turn it over to the attorney until the 10th. Then the attorney, it might take him another 6 days or so to file the motion, and then you've got a brief window of opportunity for a hearing. But if your judge is out of town, or if they ride the circuit, some in rural jurisdictions they still ride the circuit, and you can't get your hearing, then you're out of days. You're out of days in the for the for the deadline to respond or have a hearing on the subpoena. And if that doesn't happen, then the material has to be turned over. You can object and you can be angry about when you get over to Duke Seacom and say, there's no way I'm turning this over, they're crazy, this is whatever it is, this is privileged or what have you. But you cannot ignore the subpoena. There is a process for you to fight about it, but you absolutely must get it in the hands of the attorney, your agency attorney, the same day you get it is the best way to do it. I mean, right then, in order to put him in the best position to respond effectively and do it within the timelines, okay? You don't want to just sit on something thinking it's ridiculous and we're going to ignore it. Because that'll be the quickest way to lose one of those motions and find yourself having to turn over stuff you wouldn't ordinarily have had to turn over. Let's look at the basis to quash motions. Maybe it's a timeliness issue. Maybe the return date is outside the required time. They didn't give you sufficient time to respond. That would invalidate one. The service wasn't sufficient. Maybe it's overbroad. Maybe it's vague. Maybe you just don't have the information. Or maybe there's a privilege in place and you don't have to provide these things. Or there's a problem with the process itself. Look at some examples here. This could be an example of one to Lori. What's the problem with this one? Anybody want to guess?
We're not calling you out or anything, Lori, but
Thanks. So this would mean as an employee of DCJS? Is that correct?
Yes. Yes.
Okay.
What do you think the problem is with the language of it?
Commanded?
Well,
let me see.
They're asking you for everything but your firstborn, don't you think?
Right. But that's not very unusual.
Wait. Yeah, I think they really have just basically, when you talk about a wide net for fishing, this is it.
Yeah, way too overbroad, and that's a way that whoever is representing you, the attorney that's going to respond, can address that and say, no, you have to give some specifics about what you want and why you think it's relevant and why you think it's out there at all. All right, look at the next one quickly here. Please provide everything related to In re Samuel Carly. Well, what does that even mean, right? That's an example of something being entirely too vague. Nobody even knows what that means. Here we go. Nikki Camp, Montana State Coordinator. This wants the screening results, scoring sheet documents, notes, and impressions. All right, now we're getting real specific.
But they're only giving me 3 days to put my stuff together.
That's right. You'll notice the date is the 6th and they want it by the 9th. Well, that's not going to work. Okay, so it's untimely. Good deal.
So we're really talking about planning ahead, right, Karen? I mean, we're giving you just a taste of discovery today, but really the important part is it's really about planning ahead and understanding.
Not being afraid.
Right.
Not being afraid of this stuff. This screener is kind of infusing you into the court system, and that's okay because there's lots of process and protection in the court system, and not a lot of reason to be afraid of it. But it's just a reality that needs to be dealt with.
You know, this is an opportunity for, again, reaching out to stakeholders because you all are not attorneys. And unless your agency has an attorney on speed dial, you're going to want to figure out some way that you're not just